What's up, everybody? Episode 4 of the Whiteboard Podcast. We're here with Leor, our preferred counsel on all workers' compensation claims. He's from Albert Mackenzie. We're being produced by Tyler, who's our stud. We're going to talk about really some proactive steps that you can do prior to a claim happening, the process and the participation that an employer can have in regards to claims, and that should be pretty much it. So let's get to it. Absolutely. Episode 4, Leor. First guest on the Whiteboard Podcast.
I'm honored.
Yeah, you should be. It's a privilege. I'm super stoked to have you on here.
Yeah.
We got introduced through a mutual friend, Matt, probably 6 or 8 months ago, roughly. Or it's maybe longer than that. Maybe a year ago. Yeah, for sure. Dude, time's going by so fast. That sucks. So a year ago, and when you and I first sat down at dinner, and you told me some of the stuff, because we're heavy in regards to how we can help our clients mitigate their exposure when it comes to new employees that they're bringing on, what to do when an injury happens. But you offered insight that I was like, didn't even think about that, because we have very little interaction with the counsel that the adjusters choose for workers' compensation claims. Like, we never talk to them. All we get notified is, okay, they decided to do a global resolution for these 2 claims and whatever. And we're like, all right, that's just what it is, and it's already been done. So when you were talking to me about the way that you and your firm work, I was like, this is something we should dive deep into, because I don't think there's a ton of other brokers out there really utilizing a preferred counsel the way that we are. And the reason why that's going to be so valuable for our clients, and hopefully for you guys too, is like, we're going to push business to you. And the reason why we're going to do that is because of the value that you guys bring and because of the understanding that you have in navigating the workers' compensation system. And obviously your numbers speak for themselves. Is like, you guys are dramatically better than other counsels out there. And so I do think that does probably come from top down, who you're talking about, Bruce, which is really, really neat. So I'm excited for the listeners to be able to hear some proactive steps that they can do in an ideal situation. Obviously that is pretty rare, but what they can do even prior to a claim happening.
Yeah, no, absolutely, John. I mean, you touched on so many points that, the reason we brought them up is because over the course of my career, it's one of those things where you talk to employers and you hear 80% of their complaints are across the board the same. Everybody's having the same issue of being kept in the dark regarding the system, not having any clear guidance on what they can do, where they can participate, where they can be active, and then at the same time, even if there are portions where the employer can't be directly active, it's still great just to be kept in the loop, to know what to expect, because the employer involvement is really heavy on the front end. The employer, because quite simply, injuries don't happen at the insurance company. They don't happen in law firms. It happens at the place of business. So that's why the employer is really on the front line, and most of their participation in the case is going to be during those initial, particularly 90 days like we're going to talk about. And as the case progresses, there's definitely still a role for the employer to play, and that type of collaboration between the employer, the broker, the insurance company, and the attorney is really key to ensure that we're moving these cases forward as expeditiously as possible, and most importantly, getting those cases closed. Because there's an adage in this business, which is just the only good case is a closed one, because they don't get better with age. It's not like a fine wine. It's quite the opposite.
That would make sense.
It's vinegar real quick. So, the faster that we can move through these things, the better it's going to be for everyone. For example, one of the first questions that the most employers have is, what's a work injury and what needs to be, what needs to be reported, which is something that you guys are already doing so great and really being proactive, because there's 2 types of injuries, of course. There's a first aid only claim, which doesn't need to be reported to your insurance company, can be kind of handled in-house, and then there's an actual work injury.
And to touch on first aid,
please,
because that's an important distinction between the way that the labor law states it, right? If they're seen by a medical professional, that first aid has to be reported to the insurance company. If this is something they can just do on site, putting a Band-Aid on a paper cut, for example, they don't have to report that, which would still be, I mean, the problem is the word first aid can be used in many different terms. So just for clarification, that's what you're talking about.
Yeah, and actually, the law on this it's a little nuanced. So something like minor cuts, scratches, and burns, is typically what we're talking. We're talking about first aid. But just because, or let's say, for example, your employee is working, he's a welder, and a spark, that he's working on flies onto his arm, and he gets a little first, maybe second-degree burn. Even if, let's say, you take him to your industrial clinic and he's seen by a nurse, if the nurse maybe wants to do like 1 or 2 follow-ups, but all he needs is a little bit of ointment, that might not fall under the injury side and really may just be more of the first aid, even though he's seen a medical professional.
I was under the impression that all first aid has to be reported. So what they've done on the experience modification rating is they've taken out the first $250 of any one medical claim, no longer impacts the mod. And what they're trying to encourage the employers to do is report all injuries.
Yeah.
I still was under the impression that if they're seen by a medical professional, even if it's deemed technically first aid, it still needs to be reported. And even if that, for example, like doesn't go over that $250 threshold and does not impact them, it still will fall on their loss runs. Is that not correct?
Well, that's, I would say there's 2 aspects of this. The first one is it's more of, by California law, what needs to be reported to the insurance company.
Sure.
However, what you may be discussing is more the insurance companies are kind of contractually requiring the employers
that makes sense.
to
Okay.
report even first aid. But the reason for that is very often we'll get, let's say the applicant has a real work injury. He'll get an attorney, and that attorney is going to start questioning him about the entirety of his work history.
Sure.
And suddenly, out of the woodworks, he's going to be like, oh, yeah, sure, last February, a plank fell onto my shoulder, and now I have this major shoulder surgery. But you know what? 3 months prior, I remember this spark fell on me, and, I got burned. Wonderful. He's going to file a whole separate date of injury just for that new injury. And when that happens, now the insurance company, or actually me, I'll go to the insurance company and be like, oh, great, give me everything you have about that prior injury. And the insurance company would be like, I don't
Never
have
heard
anything.
of it. Oh, yeah, that would make sense.
Having, keeping the insurance company in the loop and, providing them with those first aid records, as you said, if it doesn't affect your premiums, that's really what you care about the most.
Sure.
And that way the employer, or scratch that, the insurance company, knows about the existence of those prior injuries, and then when they do become
we have a
litigated,
document trail, and
already
this is
have
what
the
happened,
documents.
which is a big deal.
Exactly.
Awesome. So what are some things prior to the injury happen? I know you're going to go on that, but what are some things that an employer can be doing prior to the injury even happening? Because I don't want to walk through exactly when an injury happens, what that looks like.
Yeah. No, proactivity, getting ahead of things is definitely the best way. Now, you can't prevent work injuries from happening themselves because they're going to happen. Of course, you can do stuff to mitigate it, which right off the bat, safety training, naturally. We encourage employers to provide safety training as much as possible about all aspects of the
document that safety training as well.
Make sure your employees are signing and acknowledging that not only they attended that training, sometimes it's even helpful to attach maybe a summary of what was discussed in that safety training. And that kind of brings me back a little bit to one of the aspects, because for there to be a compensable work injury, it has to be an industrial injury. Now, the legal definition, and this is a phrase you're going to hear over and over again if you're an employer and engaging these work comp claims, is AOE-COE. AOE-COE means arising out of the employment or in the course of employment. So in order to have, just because an injury happened at work during work time or even off time, that doesn't necessarily mean it's either compensable or not compensable. What you're really looking for is whether or not the employee is engaging in an authorized activity or not. So, for example, you have a lot of times where you have an employee and maybe they're doing things in the incorrect fashion, but they're still doing it they're still authorized to do that activity.
Sure.
So maybe have an employee who's, like I said, doing welding, and that spark flew and fell onto his arm because he wasn't wearing the gloves that he's supposed to. Well, those gloves are part of the best practice. The employer, insists that he use them. But you know what? In the workers' compensation system, since we're no fault, then that would still probably be a compensable injury, since there's a degree of negligence that's allowed. But on the flip side, let's say he's engaging in an activity itself that wasn't authorized. And not only is he engaging in an unauthorized activity, he's also doing so in a manner that wasn't authorized. So now maybe he's using a piece of machinery that he's not supposed to, and he's operating in a fashion that he's not supposed to and was instructed not to. Well, training would come in to prove that he wasn't acting in an authorized manner and doing an authorized activity.
Whoa.
So if that happens, that injury is not compensable, and we can actually fight that, because you, the employer, shouldn't be responsible.
That is awesome.
Yeah,
that's really good. We had a claim
kind of
4
stuff.
years ago, which in retrospect, I was like, I wish I would have known you 4 years ago, is one of our clients had one of their employees on break at a separate property climbing scaffolding, and he fell off the scaffolding and filed a workers' compensation claim. He was on break working, not even working, screwing around on scaffolding on someone else's property, and he got an attorney and he got money. That shouldn't have happened.
Like, once again,
obviously there's some details there that I'm probably listening out like, yeah, it's BS. Okay.
Yeah, no, just as far as these things are concerned, right, is the law is laid out by the legislature, and they can only do so much.
Sure.
Because there are 1,000
circumstances.
There's infinite number of jobs and infinite number of variations of how that job is done.
Yeah.
So all we're doing is basically applying the law to the facts, and then it's up to the court to decide. But under the facts that you're describing to me, at minimum, we have what we would call in the business a viable defense. And a viable defense is something that you can either go to trial on and potentially win. So yeah, we knocked out the whole thing. Or at minimum, maybe I can leverage that for a much cheaper settlement because it's not necessarily open.
That's super awesome. Okay, great news. So safety training, key, document that you did that, because that can go into account if they're screwing around doing something they're not supposed to.
I mean, that also, that kind of brings me to some of the defenses that an employer can keep in mind and keep track of. And one of them, for example, it's called horseplay or skylarking. But it kind of ties in directly to what we're talking about this unauthorized activity in an unauthorized manner. So if you have two employees and they're doing maybe they're both forklift drivers and they're having forklift wars and they're just...
Dude, where is this happening? Let's go. Yeah.
Coming to ESPN2.
Yeah, exactly. ESPN 8 the Ocho forklift. That's awesome.
But, if you have two guys bashing forklifts together, that's clearly going to be considered, this horseplay skylarking, and that's not something the employer should be paying for. And, maybe you can sue your employee for damaging your property, but that's, of course, that's a separate matter. But, that's an example of, you really want to be very clear with your employees what the expectations are, what the work duties are, and also, and I can't stress this enough, document. So if you have an employee who's not performing the duty in an authorized fashion, don't just give him, a quick verbal warning. Document it. It doesn't have to be, it's one of those things where it's not what you say, it's how you say it.
Sure.
So, documenting an employee for not following company procedure doesn't necessarily have to be this really scary, how dare
See you
you
Thursday
kind of
at 4 o'clock. We got to talk about this.
I'm calling you into the principal's office.
But yeah, being tactful and being aware of like how this is going to be, handled and understood from the employee side. So using kid gloves a little bit and making sure they know not to do it again. And it is that thing, man. I always tell every single one of my clients this is like, we can do everything in the world. You guys can go through all kinds of safety training. You can have us involved, like managing the claims. The reality is culture is paramount. If you have a culture where like everybody feels okay to kind of self-police, everybody feels like, I don't want to say entitled, everybody feels okay to go to their manager and say, this is going on. And then going the other way is like if someone's screwing up, doing that in a way that would not make them fear for their job necessarily or anything like that goes a very, very long way. Because I know when people get written up, they're like, oh, this is my second one. Or if it's my first one, I've only been here 3 months, like the red flags start going up for them. Like, oh, if I get another one, or if like, there's traffic, I show up late to work, like I could get fired. And that kind of insecurity can drive really, really bad behavior.
Yeah, no, that insecurity can also sometimes drive people to file claims.
Yes, yeah, absolutely.
They're planning their exit strategy because maybe the employer was a little too harsh, or wasn't communicating what the actual effect of this offense is.
Yeah, so do that. Don't be a dick. Okay. Yeah.
I mean, that's probably a real good rule for life.
Yeah.
in everything you're doing.
That's awesome.
But yeah, so. Document. Be very clear with your employees. Provide safety, and like you said, just mark down and do them regularly.
Sure.
Oftentimes, I have employers that like to do monthly. Some like to do something small weekly.
Yeah.
But a lot of times there's a he said, she said in the courtroom, and I have to rely, of course, on the employers and the employer testimony, and then the injured worker is going to get up on the stand and provide their testimony. And the court is essentially going to do a credibility check.
Gotcha.
They're going to decide who do I think is credible, who's telling the truth, because now I have two very separate opinions.
This is the judge doing this, correct?
This is the judge.
Okay.
They're the ones who make the credibility decisions. They decide who's telling the truth and who's not. So one thing to keep in mind is in the workers' compensation system, there is a built-in, it's called a thumb on the scale for the applicant. The tie is supposed to go to the runner because we have this no-fault system.
That makes sense.
So as a result, we as the employers, we're held to a higher standard. So when I'm in court and I'm putting my employer up on the stand, if I can then pull in his risk manager, pull in his HR manager, and I can actually have him testify to prove all of the procedures that they have in place, all the steps that they do, everything they document, which just shows how above board everything is being done.
Sure.
The judge is going to give them so much more weight when the applicant
that thumb gets lifted a little bit and be like, all right, well, they're doing everything right. This guy's just saying things. We have all this documentation. Interesting. Okay, that makes a lot of sense.
Just kind of bolstering your credibility from the outset just by showing that you're doing everything by the book.
Gotcha. That's a big deal. So once a company has implemented appropriate training, appropriate acknowledgement, and that's something I want to touch on too, the acknowledgement, they understand how to file a workers' compensation claim. They understand the importance of if you get injured. It's absolutely crucial, even if you just want to rub some dirt on it and be okay, to tell your manager that this happened, and that manager then reports to the person who is responsible for reporting workers' compensation claims.
Exactly. Right? I can't tell you how many times I'm in a deposition and I hear a variation of one of these things, which is one, we were discouraged from filing claims or reporting claims. Two, I reported it, but the manager laughed at me or ignored me or didn't do anything. Or three, I didn't know who to tell. There was no procedure in place. I didn't know how to act.
Sure.
And now we have the system where when the applicant gets in trial and he's standing for the judge, he's going to have a little thumb on the scale in his favor. So if we can push back on that and prove that no, not only did he know he was supposed to report to his maybe direct supervisor, he could have reported to the floor foreman. He also knows the HR lady who he also could have reported it to.
Sure.
So it's like these were 4 separate points of contact that he was explicitly told that he could.
He signed that he understood.
Exactly.
Gotcha. That's a really, really big deal. That's awesome. It is pretty funny. I meet with a ton of prospective clients, and it would shock you how many times, like, do you guys have a hitman service? Because these guys are taking advantage of me. Like, those are the type of things that come up sometimes that are like, it's such the opposite way to look at your employees. Is obviously you're going to get some bad apples, but the reality is like 95% of the employees are just in here to do their job. They are going to be fair with you, but those 5% is what you have to look out for. And that is one of the things that, like, it'll make a lot, and I see this. You see someone who's been doing this for 30, 40 years, and I'm like, I get how you can be pissed off and not trust anybody after getting sued 100 times over your 30 or 40-year career. Like, I totally understand that, but you're just exasperating the issue. Like, that's all that's happening is, like, you keep mistrusting people and not putting these things in place, and all you want to do is, like, fire people and be hardcore. You're like, all right, well, you're going to get those employees who will fight back with you, and because the thumb is on their side, that really puts a stick in their ability to defend themselves.
Yeah, I mean, actually, just to give you an example, I have this case I'm litigating right now with it's a post termination claim, which we'll talk about at some point. But that's one of the important defenses is when an injury is reported after the applicant's already fired.
Or quit, right?
Or
does that matter?
Potentially, yeah.
Okay.
Yeah.
Sorry for screwing you.
No.
Keep going. Yeah.
No, it's like 45-minute conversation.
Yeah, exactly.
Okay, but anyhow, in this case, we are now disputing whether or not he reported his injury before or after he got notification by text message that he was fired.
Interesting.
So the employer, I asked him, and he provided me with text messages. The text messages do seem to support the employer's, argument that no, this guy said he wasn't going to show up to work. So I told him, you know what, this is the last straw. He had a history of alcoholism and not showing up to work, so fine. He fired the guy. And then the text messages indicate that the applicant was fired. But the reason I bring up this story is because you read the text messages between the employer and the applicant, you can tell the employer was one of these jaded guys.
Oh, sure.
And he's dropping F-bombs and being like, can I curse? I probably shouldn't.
Fuck yeah, you can. It's okay, dude.
But, he's saying, I don't give a fuck about none of these employees. It's nothing about me. Everybody's trying to screw me. I know you're just trying to lie. Go ahead. Get your claim taken care of. Do it on my dime. Do it on my X-Mod. It's happened to me before. I'll be fine.
Yeah.
Sorry, Bruce. But but the point is, I'm now going to show that to the judge because it's proving our case, but it doesn't look good.
Yeah. Those are bad things to have in front of someone.
And that's a guy that that kind of mentality probably bleeds over into his management style and how his employees feel, which it's not going to help you in the long run.
Yeah. How you do anything is how you do everything. That really comes clear when you get employers who are like, this is just how I'm going to do it. And just give a middle finger to everybody like, all right, dude, well, you're going to pay that back. For you not lowering your ego, you're going to pay that back in dollars. And in a ton, potentially a culture that now your managers start acting like that to their subordinates. You're like, probably not smart. Yeah. So injury occurs. Let's just say it's a lower back injury, so a strain. It's pretty severe. They go in to see a doctor. Mm-hmm. What are the steps from the injury, getting reported to the insurance company, first visit to the doctor? How does that process work? And then where can the employer participate in that system to make sure all the facts are out in the open and they're doing everything they can on their end to help mitigate their potential future loss?
Yeah, and I'm really glad you used the word mitigation, because in the fact pattern you just gave me, we are now dealing with what appears to be an undisputed injury. Yeah. So the injured worker is at work. He presumably reported it timely and was sent for treatment. So the first step, of course, is, if an injury is reported, you should send him for medical treatment so we can get him checked out. The other thing that you should do is, so we have by law and then what I'm just going to call best practice. So by law, the first thing you have to do is you have to provide the employee within 1 day of notice of the injury. We can talk about what constitutes notice and doesn't, but let's assume this very straightforward scenario. So there's this form in California, oftentimes referred to the DWC-1, very standard, and essentially it is a claim form which lays out the applicant's name, their address, their personal information, the date of injury, how the injury occurred, and then what body parts were injured. And that last one is so key, because from the outset of any claim, we're really just trying to lock in everybody's story. Because by the time the case gets to me, it might be 2 to 3 months. By the time it sees a judge, it might be 2 years.
Yeah.
And memories are very faulty, no matter how much people insist. They remember everything. I'm sharp as a
photographic
wick.
memory, dude. I got it. This is what happened. That's why we record. So when we get notified of an injury, the first step is the injured employee goes to their supervisor. From there, they both get on the phone with our triage unit. We do an initial triage and record the statement of the injury. And the reason why we do that is for exactly what you're talking about, is a lot of times even a day will pass and like, well, my back hurts and now maybe something else hurts. And that doesn't mean we're trying to limit if you actually got injured, but it does mean like, let's lock in the story. Let's figure out exactly what happened. And then for you to build your case, like, well, now we have a story from it actually happened the day that it happened from the injured employee's mouth.
Exactly. And he's going to fill out this claim form. And then when he's going to say, describe, body parts affected, maybe he's going to put back, let's say maybe he throws in his right shoulder. Oh, my right shoulder is sore too.
Yeah.
Great. Well, 6 months from now, when we start litigating or, we're in a deposition, which will probably be sooner than 6 months, but regardless, we're in a deposition, he starts saying, oh, yeah, now it's my left shoulder, and it was my neck, and it's my leg. Yeah, they hurt, but I just didn't, I didn't report it at the time. It didn't seem important.
Yeah.
He can make all the excuses he wants, but this is still, he's essentially contradicting himself in the past.
Sure.
So instead of having a scenario where it's he said, she said, employer versus the injured worker, now it's actually the injured worker versus himself.
Yeah. What he put on the piece of paper and said this is what it was.
So kind of to piggyback on that best practices, in addition to this DWC-1 claim form, which, by the way, you need to provide to him within a day, the employee should then fill it out, give it back to you, and then you fill out your portion as well, so that way you can advise, put down what your insurance policy is, acknowledge when you gave the employee that claim form, when you knew about the injury, since these are all extremely important things. But the other thing that I highly recommend is 2 separate incident reports be filled out by the employer. The first one is an incident report by the supervisor to whom the injury was reported.
That's a great idea.
So the supervisor is the one who, presumably came to the scene first, evaluates the workplace if they weren't there at the time, but, they're going to interview their coworkers, they're going to lay out exactly what happened, and also relay what the injured worker said to them, and potentially from the employer's perspective, which could be very helpful, is because they're so close to this, they can probably make recommendations for, future safety procedures
absolutely.
In order to rectify some things. Oh, this cap on this buzzsaw, it looks like it did come loose. We need to be careful about these caps. So there's a lot of things that the supervisor can then do, but now we have essentially the employer's side of the story about what happened.
And that would include, so supervisor goes out to a job site, for example, and 3 people saw it. Would the supervisor be in charge of getting their stories on what happened? I talked to Mike, I talked to Jose, like, this is what they saw. Would that be included in there?
All helpful. Sometimes I see employers actually also give those injury reports to coworkers who observed it.
Sure.
Because, we want to, assuming this goes to trial 2 years from now, and I do want to call, maybe that employee, because maybe there was horseplay involved.
Sure.
Or maybe, he really cut his hand, but suddenly he's saying he injured his left leg and that he fell. Well, if there was a coworker there, be like, no, I didn't see him fall. There was no fall. He was just sitting on his stool, and then he reported his injury. So you could have the
continuity
witnesses.
of narrative. If like we have the employer and 3 witnesses saying, "Hey, this is what happened," and he's saying something different, like we go back to the credibility issue, right?
Oh yeah,
makes sense.
But then this actually brings me to the next one, which is just as important for the same reason why we were talking about why we want that DWC-1 filled out. You should give the employee their own incident report and let them fill out in their own words exactly what happened.
Sure.
That way, it's not the employer interpreting events. It's not the employer maybe paraphrasing what the injured worker said. It's like, no.
What if they don't write?
If they can't write, then you would ask.
It's remarkable how common that is.
No,
it seems like a dumb question, but
it's not. And we employ a lot of people from a lot of different backgrounds. So just because you can't write, that's fine. The recorded statement would certainly be helpful, or you simply have someone that they feel comfortable with assist them. And then merely at the bottom of the form, you would simply have them
put your mark.
Yeah, no, but I would say note, have a notation. Oh, assisted by
I understand.
Coworker Dave Marks, who actually helped him fill it out. But the idea is we really do want the injured worker's opinion and story of what happened as close to when the injury occurred as possible. So then later on, when we're in that deposition, years from now, potentially, when we're in trial, he can't start changing his story because it was his words that we'd be using against him, not just the employer's.
That's awesome. Okay. That's helpful.
Yeah.
That's really helpful. What else you got?
The next one of
Tyler,
these...
how are we doing on time, dude? We have a sushi date.
9 minutes and 4:59.
Oh, my gosh. Okay. We got 5 minutes, dude.
Okay, let's wrap this up. Well, the next important form is what's called this Employer's Report of Occupational Injury or Illness. This is, again, a form provided by the State of California Department of Industrial Relations. So this is a standard form that you should be filling out. And this needs to be returned to it needs to be reported to your carrier within 5 days.
Gotcha.
This form is going to have a lot of similar information, but it's a bit larger. So it's going to have more information about it. It's going to ask you your type of business, when the injury occurred, if the employee returned to work, what body parts are at issue, what their wage information is. That's going to be very helpful for determining what kind of benefits they may be entitled to. Did you send the applicant for treatment? Where did he treat? All this information is going to be extremely helpful, once again, for your insurance company to get a jump on the investigation portion, which...
That first 90 days.
Exactly. That first 90 days, because we were discussing, we were kind of making an assumption here about this very straightforward case with this lumbar strain where everybody knew what was going on. But maybe you have a scenario where your worker, Dave, shows up on Tuesday and goes, oh, yesterday, I hurt my back while I was lifting a box in the warehouse, but I didn't report it to anybody.
Yeah.
Okay, well, he reported it the next day. Maybe Dave has red flags, maybe he doesn't, but the insurance company now and the employer, because the knowledge for this 90-day period is for both.
Sure.
So it's not like just when the insurance company knows, it's no. If the employer knows, but they don't tell the insurance company for 30 days, you just wasted 30 precious days of investigation before we need to decide if we're going to accept the case or deny the case.
Sure, that makes a lot of sense. That is on loss runs. Not every single carrier does this, but a lot of carriers, the best ones do. ICW does, Zenith does. I shouldn't say the best carriers. Carriers that look like they care the most about the claims management and want to actually have a partnership with the employer, they actually put those metrics on the loss runs, date to report. And then they give a summary at the end and saying, here's your average date to report. And the reason why they monitor that is it's even a 15-day average date to report can balloon claims up.
Absolutely.
Like I don't know exactly what the metrics would be, but I would imagine even compared to someone, hey, we have 1 day report or 15 days report, that could be thousands of dollars in claims costs that maybe not needed if they have a better reporting system.
Absolutely.
Okay, that's awesome. We'll do this the first of many. I really appreciate you doing this and taking the time to do this. This is awesome. I'd like to have you on a bunch. Get Bruce on here if this goes well.
Absolutely.
Yeah, you're just not allowed to swear in front of him?
Yeah.
Okay, good. Sweet. Lior, thank you, man. I really appreciate it.
Yeah.
All right, guys. Have a great weekend. Talk to you next week.
Bye, everybody.
Bye.